So, police make an arrest, police decide to proceed with the case, police then turn it over to the courts. It's the prosecution that would take the case from there. Some of you probably watch these television shows about the interactions between police and courts, like Law and Order or other ones, and I watch them. I love watching them. But they certainly oversimplify the relationship between the police and the prosecution, and they oversimplify the way that the courts operate. In particular, there are some digital crime type movies and television shows that focus on how the police and courts respond. And those don't necessarily get us an accurate picture. They create a very interesting picture, but what we'll talk about is how in the courts, who we have responding to these cases and how they do it. And then we're going to conclude the criminal justice module with talking about how we punish these offenders. So this will be our last criminal justice module to talk about all of what we think is important to know about cybercrime and criminal justice. When we talk about the courts, the actors in the courts, you have the judge, you have the prosecutor, you have the defense attorney, you have the defendant, and you have witnesses. Now, judges, their role is to ensure that the case is administered fairly. They're the arbiter. They're the one in charge of the courtroom. Prosecutors, they're called district attorneys some places, but they're the ones who decide whether or not to proceed with the prosecution, whether to accept a plea bargain, which has to be approved by the judge. They decide whether what to charge the defendant with based upon recommendations either from a grand jury or based on their own decisions. Defense attorneys clearly have to represent the defendant. In this case, our cybercrime defendants. The defendant would be that individual who has been charged and is being prosecuted. Now, when we talk about witnesses, we have what we call lay witnesses. Lay witnesses are just regular folks that may be witnesses that saw something happen or that know something about the crime, a relative of the defendant or victim or someone like that. We also have expert witnesses. These would be in digital crime cases, people that know a lot about cyber forensics and digital forensics and how to interpret the data. And there's also the professional witness in these cases, and these would be people like the criminal justice investigators that got involved, the digital investigators, or any experts that are testifying on behalf of the state that worked on the case for the state. Now, similar to virtually all types of crime, when cases are prosecuted, cybercrime offenders are more likely to plead guilty than to go to trial. Estimates I've seen are anywhere from 90 to 95% of cases are pled out before they get to trial. And there's a number of reasons that defendants plead guilty. One is to get a lesser charge. So they may be charged with, say, a first-degree offense that is a felony, and the prosecution may offer to drop it to a misdemeanor if they plead guilty to this type of cyber intrusion. So that may be enough to do it. They also plead guilty for promise of a lesser sentence. They also plead guilty because it's cheaper. I mean, it costs a lot of money to go to trial. And to spend that money and risk receiving an even longer sentence, those sorts of things cause our offenders, including our cyber offenders, to be more likely to plead guilty. Now, there are a number of challenges that experts have talked about. McAndrew, in particular, has written about some of those challenges. For example, because these cybercrime cases are so new, prosecutors are still figuring out what should be the appropriate charges. Could someone actually be charged with burglary if they're breaking and entering? Could someone be charged with just traditional type of fraud rather than an electronic crime? And figuring those things out is not necessarily that easy for prosecutors to do. Also, when cases do go to trial, the technical evidence could be sort of confusing to jurors when they start hearing about bots and software and algorithms and sorts of things that aren't part of our normal nomenclature. That sort of evidence may confuse jurors, and defense attorneys are able to pounce on that confusion. Also, it's hard to figure out how much was actually lost. If a cyber offender targets a large number of people and a large number of people were victimized, who all were victims and how much did they lose? And how do we translate that to a jury or a judge in a way that helps to demonstrate the true harm from that particular crime? Since these cases are so rarely prosecuted, another concern is that no matter what sentence the defendant receives, defense attorneys will say that's unusual. And our Constitution prohibits cruel and unusual punishment, and with a small sample of possible sentences to pick from, it does provide the defense attorney that opportunity. These cases also take a long time to prosecute. The searching cyberspace, gathering the evidence, getting the evidence to make sense, the prosecution of these cases can be much more time-consuming than your traditional types of cases. Victims might also be unwilling to participate, and this is something that happens in all types of crime. But again, in cybercrime, it may be even more salient. Victims, particularly companies, don't want people to know that they're vulnerable. They don't want people to know that you shouldn't shop at this particular company. They don't want people to know that they hired someone who turned out to be a criminal. They don't want people to know that they have failed in protecting the security of their customers' data. And because they don't want people to know these things, they may be unlikely to notify law enforcement. And then if law enforcement finds out and they prosecute, victims still don't want to participate, and they can't be forced to participate. That makes it challenging for law enforcement, and in this case, for the courts. So let's turn to corrections in cybercrime. And this is once a conviction is received. Now, if they're convicted, cyber offenders, most of them go to jail or prison. Now, it's key to point out that most cyber offenders never get caught. When they do get caught, and they make it all the way through the system, if you're advising them as an attorney, you probably ought to be telling them to take a prison preparation orientation class, because if they get convicted, they are likely going to prison. I did a recent study with a student at Claflin University and a colleague here at Old Dominion University. One of the things we found was that males got longer prison sentences than female cyber offenders. There's other research that's been done that looks at gender patterns and finds that while there's gender patterns, there's still, the other studies also find no differences in sentencing. Sanctions tend to be justified on deterrent ideals. Judges in particular will say, I'm going to send a message to everyone that this is a naughty act that you shouldn't do. And prosecutors will say, this should send a message to all cyber offenders that we're coming after them and you can't hide. Well, that sounds good, and it's a wonderful soundbite, and it makes the news. But I'm not aware of any studies that have actually found the deterrent value of those sorts of prison sentences. Now, they have a specific deterrent value, obviously. They're going to keep that particular offender from doing it again while they're incarcerated. But the idea of sending a message, it's not being heard because cybercrime continues to increase. And it calls into question the value of justifying sentences based upon those general deterrent ideals. Here's a study I did with my two colleagues, and this was federal data that Brittany Hawkins analyzed as part of an NSF research experience for undergraduate project she was working on with myself and Dr. Chun-Cheng Chin. And it shows the patterns I was mentioning, and one of those being they're going to prison. Again, no differences in terms of who's going to prison, and because so many of them are going. We also found that fines were rarely used. Restitution was used a little bit more. Restitution is when you have to pay the victim back. A fine is when you pay the government back. Probation, uncommon, and community service, also uncommon. But let's point out that these are probably part of the reason we found those uncommon is a lot of the sentences that were given to defendants would say things like, you're going to prison for X amount of years. Once you're on off prison, you're on supervised release for an additional amount of years. Now, supervised release is, you either call it probation or parole. It's essentially the same thing. It means that we're going to keep our eye on you and we're going to make sure you stay out of trouble. So there are far more cyber offenders serving sentences in the communities after a stint in prison than these data would suggest. So because they're working in the community, probation officers have to be prepared to work with them. And with probation, a number of issues arise, and an author Newville has talked about some of these issues. One is a new offense. Probation officers are going to need to be trained in these areas. They're going to need to be trained how to search people's computers. If there's a probationer that they're overseeing and the person is allowed to keep their computer, they're going to have to know how to search that computer. There's also going to need guidance in determining the conditions of release. When someone's placed on supervised release and probation, they don't just get to roam free. They're told, you can't go out at dark. You can't go on a computer. You have to install this kind of software. Whatever those conditions are, they make that determination. There also is the point that there may be different supervision strategies used for cyber offenders based upon the nature of the offense. And that's something the Supreme Court has said. Supervised release supervision strategies have to be connected to the offense. You couldn't say to a cyber offender, you have to put a DUI breathalyzer device on your car before you drive, because that has nothing to do with their offense. But you could limit their computer use. And the other thing that comes up is that probation officers need to have the hardware and software that's needed to search the offender's computers. Newville provides a sample of types of conditions that might be given to probation or supervised release cybersecurity offenders or cybercrime offenders. There could be no access to the internet. So you can have a computer, but you can't have the internet. You could require defendants to provide their bills, their monthly internet phone bills, and so on. You could, the court has agreed, require offenders, if you're allowing them on the internet, they got to disclose all of their accounts, including their passwords and their usernames. You could limit access to modems. You could make them use filtering software, or prohibit them from using encrypted technology. And also there's opportunities to use activity tracking and reporting software. Offenders would have to agree that their computer and their family's computers could be searched at any time. They would have to provide a software or hardware audit at the onset of a case. So if we're letting the family keep the computer, they're going to come in and they're going to look at the computer and see what all's on it. And they would need permission under some conditions to add new hardware. As I mentioned, they could be told you can't go on a computer ever, or they could say that there's no use of any device that would allow anyone to access the internet or an online service. These are just a sample of conditions. Now, the trick, again, is that we tell defendants when they're placed on probation or supervised release, these are your conditions. Someone has to watch that person, oversee them, and see if those conditions are followed or not. And that therein lies the issue for probation officers or community corrections officers to need to know something about technology. This isn't the way that they started supervising offenders back in the mid to late 1800s when probation and parole was first created. This is a different strategy. And as with the theme that has been going throughout our course, technology has changed the way that we punish offenders. Technology has changed the criminal justice system. It has changed the types of crimes people commit. It has changed the way that criminal justice officials respond to crime. It has changed the way that the police address crime. It has changed the way that the courts operate and the way that offenders are punished. And it has changed our understanding